Good morning. I'm Mary Grace Diehl, and I'm a bankruptcy judge in the Northern District of Georgia. It's currently serving on recall status, and I have the very good fortune to serve as the moderator this morning with 5 of my terrific colleagues. But I do have a couple of logistics and thank you jobs. So first of all, logistics. CLE and CPE pop-up codes will be given in the chat function. So you have to keep your chat open. And when the code comes on, you have to write it down because you need to present it at the end of the conference, which luckily is just tonight, to get your CLE credits. So watch those, keep the chat open. The second thing is the chat function is also where you will submit any questions for the panelists. We welcome questions. You submit them on the chat and they will go to IWIRC, and then the IWIRC folks will channel them back to us. So please feel free to ask your questions throughout the program. Now to thank yous. First and foremost, we need to thank Alexis Leventhal of Reed Smith, who's a member of the programming committee. She is the lovely person who put together all the materials so that we can get the CLE credit. And she kept all of the judges on this panel on task so that we could get the panel put together and rehearse and everything else. She was great. Thank you so much, Alexis. Second of all, we have to be sure to thank our IWIRC sponsors today, because it's because of the support of these sponsors that IWIRC has been able to expand its membership benefits, increase its educational programs and networking events, as well as grow the number of local networks worldwide. IWIRC sponsors receive a valuable range of benefits, including consistent exposure to the brand's over 1,700 members, and all from all facets of the restructuring and solvency community. So today we're going to highlight our gold sponsors: Baker Hostetler, Force 10 Partners, Keene Summit, Miller Canfield, and SM Financial, as well as our silver sponsors: Baker Tilly, Barron Business Consulting, Buckalter PC, DeMar Brophy LLC, Godfrey and Kahn SC, Goodwin Law, Mackinac Partners, Riker Danzig, Steichman Elliott, Thornton Grout, and Finnegan LLP. It's a lot of them, and we're thankful for them. So now we're going to introduce the panel. This was an idea that actually Michelle Pickett, the global chair from last year, had come up with because she saw so many of good, active IWIRC members were all of a sudden becoming members of the bench. And she thought, wow, you know, that is so great, but it's also something that a lot of younger IWIRC members think about. And it's really sort of a mystery to many people. How is it that people come to be bankruptcy judges? And so her idea was, well, let's put together a group of IWIRC members who can talk about their journeys to the bench. And so in putting together the panel, we tried to, first of all, represent a number of different circuits, people who had come to the bench at different ages, different ways that we got there, people who had different practices. So everybody could sort of understand how we all got here. So we're going to begin the program by having each panel member give kind of a 2-minute introduction. And panelists, it's important to tell people the district where you sit and the year that you were appointed, and then give a brief description of your career that got you to this point in time. So I'm gonna start with the First Circuit. Janet, Judge Bostwick, you want to kick us off here?
Sure. I'm Judge Janet Bostwick. I'm sitting in Boston in the District of Massachusetts, and I came on the bench about 18 months ago, September 27th, 2019. So unlike some of my colleagues, I at least had a few months before we went completely remote. My practice, and I came at a different point in my career than many others. I came at a point when many of my friends and colleagues were retiring instead of embarking on a new career. So I am proof that it doesn't matter at what age you decide, there's still an opportunity. My practice in Boston had always been in Boston. I spent about 20 years at firms that range, two firms. They both would have been considered mid-sized when I started. They were the same size when I ended and were considered small, but 40 to 70 lawyers. Our practice was business bankruptcy, doing debtor work, sophisticated Chapter 11, as well as creditor and trustee work. And I then made a huge leap and became a true solo. And I was a true solo for 18 years. I still concentrated in business bankruptcy, and throughout that, I was very active in various professional organizations, including IWIRC. I founded the IWIRC New England Network and was chair of IWIRC for several years, as well as being involved in our local bar organizations and other activities.
Okay, let's move to the Third Circuit. Christine?
Good morning. Thank you, Mary Grace. Good morning, everyone. This is a fun panel to be on. I sit in Trenton, New Jersey. So I am in the Trenton vicinage in the District of New Jersey. I was appointed on July 1st, 2013. So I'm about halfway, a little bit beyond halfway through my term, which is a 14-year term. I, like Janet, also came to the bar later. I think I was 58 when I applied for the job. Prior to taking the bench, my immediate job just prior to taking the bench was with a smaller boutique bankruptcy firm in the Trenton area in New Jersey. When I got out of law school, I got out of law school a little bit later as well, clerked for, I was living in Rhode Island at the time, and clerked for the Rhode Island Supreme Court for a year, and then worked in a big firm, probably mid-size now, Judge Bostwick, as you said, although I think that's trending the other way at this point. And in that firm, I was in the litigation department, and the litigation department assigned me to the corporate and banking departments to represent them in the bankruptcy court. So for the first 7 or so years, my experience in bankruptcy was representing mainly secured creditors in the court. When I moved to New Jersey and took this job with the smaller firm, it was mainly a debtor practice. And I looked at the bankruptcy code and thought, wow, there's a whole lot more. There's a whole lot more to the code that you can do with debtors than you could do with just creditors. So my career evolved somewhat that way. And I've been involved at any time in my practice with local bar associations, the state bar associations. I think that's so important for so many reasons: networking, personal satisfaction. IWIRC has been wonderful. And especially in the bankruptcy field, as you all know, I'm sure there are so many opportunities to get involved in professional associations, different professional associations, and that's always been important to me in my career.
Okay, we're going to go to Elizabeth. She's the DC circuit, but I'm going to call her kind of the fourth. So,
so I'm Elizabeth Gunn. I was sworn in September of last year. I have never actually sat on the bench. I've done all of my judging by Zoom. I also got sworn in from my living room. I am the only bankruptcy judge in the DC circuit. I am surrounded on all sides by the Fourth Circuit, but I am in my own circuit and the only bankruptcy judge in that circuit. I am on the other end of the age range. I was 39 when I was appointed to the bench. And I came through from the state government. I spent the first 5 years prior to being a judge as an assistant attorney general for the Commonwealth of Virginia, doing the domestic support work in Chapter 13 cases. And in the 10 years prior to that was at very small firms, I guess, comparatively, 20 to 30 attorneys, doing everything from Chapter 7 trustee representation. I was in Richmond, so we had pieces of a lot of the big cases you have seen come through the news in the Richmond division, as well as debtor work, individual 11s, individual non-consumer 7s, and I had a wide variety of background, but I came into a circuit where I am the only judge. I do have Judge Diehl sitting on recall, but he is not taking bankruptcy cases. He's assisting the district court and the magistrate courts at this point. So my experience is a little bit different, but I also was involved, and I was one of the first 40 under 40 for the ABI. I'm involved in IWIRC for over a decade, as well as state bars, and I echo what Judge Bostwick and Judge Gravelle have said about all of those organizations. So I represent the other end of the age spectrum, I suppose, on this panel.
Okay, let me go to Jessica in the Sixth Circuit. And Jessica, you're on mute, so be sure to unmute yourself. And Jessica had to drop off kids this morning, so we appreciate her joining us so early.
Thank you, and I made it back. So like Judge Gunn, I turned 39 the year that I was appointed. This year is my 10-year anniversary, and I am sitting in—
And tell us where you sit. Tell us
Yes.
where you sit.
I am sitting in the Sixth Circuit, the Northern District of Ohio, in the Eastern Division. So there are 7 of us presently, and I am in Cleveland. And when I started out as the law clerk to the Honorable Randolph Baxter, who is the judge that I replaced. So I started off as a law clerk, left being a law clerk, went into practice. I was a commercial bankruptcy lawyer by trade. Unlike some of the other judges, I did not ever work for banks. I did creditor and debtor work, but never for the secured lender. And did that for many years, rising to the rank of partner at my firm. And then in the background, what I was doing was the Bar Association work. So regional seminar chairs, rose up to be the chair of the bankruptcy and commercial section. So when I was appointed, I was expecting— I just had my first child. And then in terms of the career transition, I was a partner who was having a baby, trying to figure out what that looked like. And what that looked like was becoming a judge. And I enjoyed it so much that I had another baby when I got on the bench. So here I am. And so I guess my point is that, you know, sometimes we think that what we're doing in life might limit what we're able to do in our careers, and that is not necessarily the case.
Great. And then last but not least, from my own dear 11th Circuit, Lori Vaughan. Lori?
All right, welcome everyone, and it's nice to see folks this early morning here on the East Coast. I am in the Middle District of Florida in Orlando, and I was appointed in February 2020, so right before the pandemic, and I was able to have like a week or two of like real hearings before everything went online. I'm in the middle of the pack. I was actually appointed at the age of 46. I had about 22 years of practice before I was appointed. I started my career off actually clerking like Judge Smith, but I clerked for the bankruptcy judge who now sits next to me, who is retiring next year. And that was really nice. We're the only 2 judges in Orlando right now. And so
that's
I started
Karen
my career—
Gentleman. Karen?
That's Karen Gentleman. Okay. Yes, my mentor, my teacher, and the person who I ask questions of on a daily basis. But after that, I went off to start practicing at a big national firm. We did a lot of Chapter 11 work all over the country, and so it allowed me to travel, doing both debtor and creditor work, mostly creditor work. And then after about 8 years doing that, I ended up in New York practicing at the same firm. And I spent a little bit of time in New York, and then decided to come back to Tampa, which is where I started, and work for a smaller firm. And so I went to kind of a well-respected but mid-sized firm here in the Tampa Bay area, and changed my practice a little bit. We still did debtor work and creditor work in Chapter 11, but I also started to do Chapter 7 trustee work, other trustee work, and really put a focus on bankruptcy litigation. And like the other judges on this call, I also did a lot of bar work. I became the chair of the Bankruptcy UCC Committee of the Florida Bar. I've been doing IWIRC for 10 plus years, and so was heavily involved in the local community.
Great. So we're going to move to our next topic, which is, as we've said, there's a number of different circuits here, and it may surprise some people in the audience that there is not a uniform process for the selection of bankruptcy judges. The bankruptcy judges are appointed for 14-year terms by the circuit court of the circuit in which they sit. But the actual procedure varies from circuit to circuit. Although everybody uses substantially the same written application, part of your materials is the 11th Circuit application, and we use that one because the time we were putting them together, it was actually online, and so it was available to the public, and circuits kind of guard their documents except when they're open. So, but most of the applications are similar. So I'm going to ask at least a couple of our panelists to describe the process in their circuits, and then I'll ask for comments from the others. So Chris, you're in the 3rd Circuit. Lots of new judges, at least in the Delaware area of the 3rd Circuit. What is your process?
Yeah, Delaware recently appointed some new judges and got some permanent judgeships. So, and actually, when I took the bench in 2013, there are 9 judges in New Jersey on the New Jersey bankruptcy bench. When I took the bench, within the 2-year period from the date I took the bench, 6 of us were brand new. So it was a real turnover right at that time. In the 3rd Circuit, like Judge Diehl said, the Court of Appeals, the Judicial Council for the 3rd Circuit Court of Appeals, appoints a merit selection committee. In our circuit, the merit selection committee is generally practitioners, private practitioners. Sometimes they can include a judge or an academic, perhaps a law professor. But when I was appointed and when my 6 colleagues, my co-colleagues that were appointed around the same time, the merit selection committees were all private practitioners. And I think pretty much the circuit will take recommendations from the chiefs of both the district court in the district and the bankruptcy court, also probably the clerks of court, as to which private practitioners may sit on the merit selection committee. In New Jersey, it's anywhere from 7 to 9. We have a larger probably selection committee than a number of other districts do. I was lucky enough too, before I became a judge, to be appointed to a merit selection committee. So I was able to see the process from both sides. So the merit selection committee reviews the written application, interviews, chooses to interview 8 to 10 to 15 even candidates for the judgeship, then recommends typically three candidates to the 3rd Circuit Court of Appeals. The names go up ranked as to where the merit selection committee thinks, who is their first choice, who's their second choice, who's their third choice. And that's after interviewing each candidate, obviously in person. Those 3 then are interviewed by the full 3rd Circuit Court of Appeals. And at least in my interview, I know that there were district judges. The chief district judge from my circuit in New Jersey was on that, was involved in that interview process as well. And then the circuit makes its decision. The process, I think I was working on my application, say December, January. By February, I had an interview with the Merit Selection Committee. By April, I had already been through the 3rd Circuit Court of Appeals process, interview, and was given the job. And then following that is the FBI investigation, and really depending on how busy the FBI is, I guess, at that point, it can be a shorter process or a longer process. But you assume, at least for me, if I knew I had the job or I was offered the job in April, I was sworn in July. So it wasn't all that long, because the process is certainly disruptive to your private practice. But and of course it's nerve-wracking. And I think that you can like in applying, when you're working, we also, in New Jersey, I'm sure everyone accepts applications from all over the country. We didn't just review, and on the Merit Selection Committee, when I was on it, we didn't just review local practitioners who were interested in the job. The applications came from all over. So although it's merit selection, certainly it's apolitical as far as the difference between the appointment of a bankruptcy judge versus a district court judge. As far as I'm concerned, everything's political. I mean, it depends on, obviously who knows you. That's important in every aspect of your life. And it includes applying for the bench. So the more you expand your contacts and your networking, the better.
Okay, Lori, what the 11th, since I'm in the 11th, I know is quite different than that. So why don't you tell everybody a little bit about the selection process in the 11th Circuit?
Sure. Yeah, the biggest difference with the 11th is, there's still two main interviews that you do, but the committee that goes out and picks the applicants that will be interviewed and that interviews them is made up completely of judges, and there are no practitioners on it.
And not
bankruptcy judges. So it's in the 11th Circuit, it will be the circuit court judges that are from your state. So in Florida, all the Florida circuit court judges, and then the chief district judge from every district. So in Florida, we have 3. And so those 3 judges will participate as well. And they take in all the applications. They usually interview for each spot about 6 or 7 people. And they will have you come down and do an interview with just those judges. And then from there, they will pick usually 3, I've seen 4, that they will send to the full 11th Circuit for an interview. And as I understand, they are ranked as well. And then you'll be invited to Atlanta to go interview with the full circuit, sometimes even the senior judges, but no district court judges are involved in that process. It's just the circuit. And then they'll make a decision. The 11th Circuit generally meets in Bank 2 times a year. So your interview is going to be during one of those weeks. You're either going to be in the fall or like February or October usually. From there, you'll find out pretty quickly if you made it, and you'll start the process. My process was actually fairly quick. I was told that I was selected in October, and I took the bench in February. So it wasn't that long, I think, as time goes. And the process itself, just because Chris talked about timing, I think I applied in June, and then my last interview was in October. And sometimes they will do, if they have 2 positions right now, they're interviewing for 2 positions here in Florida. There's going to be a new judge in Orlando, and they're replacing a judge in Jacksonville. They actually combined the process. So now it's basically doubled the numbers, and they're interviewing for those 2 spots currently.
Okay, so Janet, Jessica, Elizabeth, anyone chime in about differences in your circuits? Janet?
I think that ours is sort of is very similar to the 3rd Circuit. Little bit of a twist. We always have circuit court judges on the merit selection panel. Similar to Christine, I've served on a couple of the merit selection panels, and there are never district court judges. You do have the 2nd level of interview at the full circuit. The other different, I think, which varies by circuit, is the moment the 1st Circuit makes the selection, they make the announcement the next day, even before you've cleared the FBI. So the good news is everybody knows. The bad news is
everybody knows
nerves about the FBI check.
Yeah, and the 11th Circuit, they don't tell you in the 11th Circuit, but everybody knows. They don't make it.
That's the other thing. Everybody knows anyways. It's just you can't publicly announce it. In some circuits you can. In others, it's that's true.
And Elizabeth, you wanted to.
Yeah, I'll say in my circuit, I did not have a 2nd level interview. I had one interview with the merit selection panel, which was a hybrid of district court judges and the circuit executive from the circuit court, and a couple of practitioners. And they sent 3 names up, and we had a supplemental packet of paperwork that was requested from us but I didn't have a second interview. I was simply selected. My announcement was made by the court officially after I was sworn in. They said this afternoon, Judge Gunn was sworn in.
Yeah.
But it wasn't under lock and key. Like I could tell folks as I felt comfortable going through the process. Some of my baby judge classmates were Delaware appointees and Southern District of New York appointees. Now they're on the bench, and they were under lock and key. We knew who they were, and we couldn't divulge the information. So it was one of the district court judges told me, you can tell people, but if you don't pass, it's just egg on your face. So I mean, essentially at some point you get okay with telling most folks. So maybe mine's different, but I did not have a second level interview.
And
So I just
Jessica,
wanted to add this. So we're, I think, more similar to the Third Circuit. So we have the merit selection panel that is the attorneys, and this last year included a retired bankruptcy judge. It's about an 18-month process from when you submit your application. Our next group of interviews is then with the Circuit Judicial Council, which includes one bankruptcy judge, the chief judge in your district, and then the circuit judges. Now, depending on the year that happens, it may include all the circuit judges, because if you get interviewed at the full meeting, then everybody is there. So you could have a small group, you could have the large group. But the one thing that was not mentioned, and I don't know if everybody does this, but when the merit selection panel in the Sixth Circuit sends the group of people that they present as finalists, that's published for 2 weeks, so everybody can comment on you. And so in that comment period, they send documents to the circuit. And then when you come in for your final interview, the circuit comes in with the binder of all the people who felt the need to talk about you.
wow, you know, in some ways, I'm glad I was the 11th Circuit. They're very hush hush. So now we're going to switch to sort of an advice topic. I'm assuming that a number of people listening to this webinar may have an interest now or in the future in applying for judgeships, and that's something we certainly encourage. Lisa Beckerman, Judge Beckerman from Southern District of New York, was on the panel last night, and she said in her, virtual baby judge school, 65% of the people were women. So, we certainly encourage diversity in all aspects of the selection process, but what kind of advice can you give people who may be sitting there now thinking, maybe I'm going to be like Janet, I'm going to have a career and then I'm going to apply, or somebody, like Elizabeth or Jessica, who might still be fairly young, but think, I can do this job and I want to do it now. What advice would you give somebody if they're thinking that is in their future, either sooner or later? And Elizabeth, you've just been through this, so I'm sure you thought this. What do you tell people? If you want to be a judge, do what?
I really think I'd start with building your own personal brand. And I know that's separate from building your career. I knew I wanted to be a judge a number of years, and I actually applied one time before, and I didn't even get an interview. I didn't get through the front door, but I spent the time between that and when I applied for this position, continuing to work on my personal brand within the bankruptcy community. I actually am in a district where I didn't really practice, so I really came in. It wasn't political in mine because nobody knew me. It was I was one of the ones from afar, or as they say, come from away. But I spent the time writing and speaking and doing good work and working well. But I was in state government, so I wasn't networking per se to form business relationships. But I kept myself out there, focused on articles or organizations or leadership. And that was one of the things they really asked me about in my panel was, wow, you've been a prolific writer and speaker. And I said, well, I've been keeping up on all of these areas in which I didn't necessarily practice, in the anticipation of hoping to come to the position. Now, people come to the bench with all kinds of backgrounds. Lori, Lisa, and I were all in the same virtual baby judge class. We have one baby judge who came from the AUST's office. It was an AUST. We have one baby judge who was a litigator and wasn't a bankruptcy practitioner at all. But one thing I can say for our entire class is that we all were very comfortable with who we were and had made our role and whatever it was we decided to be in the community we were in a focus in our life and our practice. We also had a career clerk who became a bankruptcy judge. So I think it's focusing on what you enjoy, a way to keep yourself not just in your niche, but keep yourself and build your own personal brand, whatever that is. And everybody's is different. For mine, it was becoming kind of an expert in the consumer law side of things, coming out of a corporate practice and having that ability to talk about both with ease and to move between the two, but also becoming really comfortable talking about yourself, because your application is 20 or 30 pages of all about you. And it's really hard to put on paper why you're so great, because all of us look at our faults and not our best parts. And so it's remembering to write down, oh, I did this thing, or I got this great feedback, or I spoke at this conference and was able to focus on this issue, and keep those notes. When did you speak? When did you write? When did you do a presentation for CARE? Or when did you do a bar training for pro bono? But keeping the records, and then also getting used to saying good things about yourself, because that's the interview. Tell them it's a sales pitch for yourself, and it is the most awkward thing because a lot of us haven't interviewed in a while, and it really is practice of saying good things about yourself. So I would say building my personal brand, keeping really good records of a way to highlight what I had done and why I might be good at the job, and then being prepared to talk about those in a way that I sounded confident in my abilities and in myself, and wasn't, I think the first time I applied, I was trying to tell them what I thought they wanted to hear. And the second, when I applied this time, I told them what I really felt about and how I really felt about the job and how I felt I could do the job. And so, it's a distinction with a very important difference. So, and obviously it worked out this time.
Yeah, let me just add what Elizabeth said in terms of keeping records. One of the values in the materials that we've given you, looking at the actual application. I think if you think you're going to apply, get that application and start filling it out, because it's going to ask you about listing cases that you've been involved in, listing people both as professional references and personal references. It's going to ask you for seminars and speeches. And, it's been a long time since I applied, but I can remember that was some of the hardest part, was getting all that stuff together. And if you think, well, 5 or 6 years from now, I think I'll be ready to apply. If you start working on that now, you'll be in a lot better position to get the paperwork submitted. But Laura,
can I add one other piece to that with the application? Most applications also ask for 5 years of CLE records. So I know, and in some states you only report every 3 years or 2 years. Some states don't report at all. Keep a record of the CLE you attended, even if you're not reporting it. Just make a spreadsheet, or if you're in a self-reporting state, report every single thing you went to. The 3 years before I applied, I had 101 hours of CLE because I had been to a number of conferences, but I had that record and I could pull it immediately. Trying to recreate 5 years of CLE and the conference you attended is, I guarantee you, almost impossible. So that's the other one that really is helpful if you're thinking of applying, and it's a long-term period of time.
And Lori, I think, did you apply more than once as well? Is that correct?
I did.
And give us your take on how do you maneuver this?
Yeah, if you go and look at the application the first time you apply, you might be surprised at some of the things that are on there. So I do encourage you to look at it now, even if you're thinking 5 years down the road, because not only record keeping and keeping track of things, but it also will tell you what you might be deficient in that they're focused on. And the things that I think are important, or at least my perception of what I thought the court thought was important, the publishing, so much of what we do is writing. So showing them that you can write. The bar activities, I think, are very important. I think they like to see people who are involved with the local bar and who have leadership positions in that way. Diversify your practice. I think personally that that's really important, showing them that you've done different things, that you have a lot of experience in all aspects of bankruptcy. And then the last one I'll mention is get into the courtroom. There are a lot of bankruptcy lawyers out there who just never go to court. They like to sit in their office and do stuff, and they do very good work. But for whatever reason, they just don't like to go to court. There are questions on the application about, how many trials have you done, or how many cases have you tried to conclusion, which can be tough for a bankruptcy lawyer to answer that
Could
question.
be years
Yeah,
and years.
yeah.
to get them to
And
conclusion.
so if you don't have a lot of courtroom experience, I encourage you to go out and get that. Go out and find the opportunity so that you can answer that question. Or if there are appeals that you can get involved in and get your name included in an appeal, or maybe even get to argue before your Circuit Court of Appeals. I think that's really important if they get a chance to see you.
I also think a way to find those sometimes can be pro bono work. If you
Absolutely.
find that in your practice, you're not get involved in a consumer case that you can actually go to court on. And then that does two things, I think, for the application process. One is the courtroom experience that Lori's been talking about. But I know that our circuit, and I get the sense that other circuits are also very interested in commitment to equal justice under the law. And a lot of that involves pro bono work. Jessica, you want to add some advice?
I do. First of all, I want to say nobody has said that they ask you to pull your driving record. That's very important. You need to slow down. If you didn't realize, I had to pull my driving record, and I was like, oh, okay. And it's been 10 years, and my colleague who was just appointed had to address some questions about her driving record. So just side note. It is a plan. It is something that you need to kind of think about. And I'm going to tell you, like I said, I've been doing this for 10 years this year. Yay. When I started the firm that I left, I came in and said, I want to be a bankruptcy judge when I started. And they're like, okay. And a lot of times we kind of keep these things to ourselves. It's not necessarily something you want to keep to yourself, especially if you're in a place that has the resources to help you get out there. And if they're looking for a speaker, oh, this can be our speaker. Oh, you need somebody on a committee. Oh, we can put this person on a committee. And then it also gave me the benefit of having paralegals that I worked with throughout the year. So I had someone who worked very closely with me who had a record of all the stuff that I had ever done. So when it was time for me to put all those things together, she was like, this is you. And it was really helpful because I came in saying, this is what I wanted to do. The firm was like, we think that this actually would be a good thing for you and for us. Let us help you.
Good. Chris, Janet, you got something to add?
I just wanted to add from the perspective of the merit selection panel, because I served a couple of times. I think everything that's been said is great. I also want to add from the perspective of somebody who kept saying, no, I don't think I really want to be a judge. This is all great advice, whether you decide now you want to be a judge, whether you don't know, because there are lots of opportunities out there. But so make sure that running list of your CV, it's useful. I have a friend who did it all the time, and she had 9 pages. So she was ready to go whenever she wanted to apply for anything. But from the selection panel, the one thing I will say that's coming across here is public interest. This is a public interest job. And it was always striking to me when we would get candidates and you'd look and they have no professional involvement, no demonstration of pro bono or public service activity. And I'm at this point in my career and I want to be a judge. And so, and that should be part of why you want to be a judge. You don't have to make that decision now as somebody who waited many years. And I would echo, so I would focus on those pieces. I would take the chances because you never know. And maybe you don't end up being a judge, but you find something different, and echo what Judge Diehl said. Pro bono gives you more opportunities to round out your practice. That was something I always looked for when I was on the selection panel. Is this a rounded practice so that they're not looking from a very narrow point of view?
Yeah,
I also
particularly,
I'm sorry, not just pro bono, but community work, things that have nothing to
right.
do with the law, things that are of interest to you. I'm a member of several women's organizations we do community service, we do projects with different aspects of the community. And what that does is not only round you out as a person, it gives you something to do once you've been appointed. Because when you're appointed, you can't go back to the Bar Association and the pro bono
Good
stuff
point.
and do those things. But if you have kind of a community service background of things that you did outside of practice, you still have that.
I think that
Yeah.
stuff also helps you be a better judge,
Mhm.
because we're all pretty much in districts where the caseload is predominantly consumer cases. And so particularly if you come from a more sophisticated, so to speak, practice where all you did was Chapter 11. I know I came from Chapter 11 practice, and there were certainly questions in the interview process about whether or not I was ready to deal with a caseload that was, 95% consumer cases. So I think you can draw on your experience in community involvement, because that does allow you to put yourself in the place of the people standing in front of you, and have a better understanding of what they're going through. And Christine, I interrupted you, so I'll give you.
No,
a-
not at all,
before
Judge
you move.
Diehl. The only thing, I think all the advice that was given by everyone on the panel is fantastic. And the only thing that I would add to that is, and it probably doesn't even need to be said, but every day, every relationship, every interaction you have with other people builds or detracts from your reputation. And bottom line, people want a judge who's going to be, or can be empathetic, respectful, a listener. All those qualities should, hopefully shine through more often than not in your interaction in private practice, which is often a difficult thing to achieve, but it all builds on your reputation.
Okay, well, now we're going to shift to, once you get this job, give people an idea of what a typical day looks like. Jessica, you've got some pre-COVID experience, so maybe I can start with you as to, what was it like back a year and a half ago? What's it like today? What can you expect?
So what's interesting is, and I think this is one of the things that you don't really realize, you plan your day. What your day looks like is up to you. Your schedule of your hearings, your cadence of your hearings, how often you're acting with the general public versus doing administrative things. And so, as you heard, I have children. And when I started my job, my predecessor would have like 8:30 meetings. I can't get anywhere by 8:30. I got to get kids dropped off. I got to get downtown. So my hearings start at 9:30. And it works for me because it gives me a chance to get into the office, get everything set up and go. And so I alternate my week. So I have a week of motions dockets and then a week of trials and pretrial dockets. And then I don't typically schedule anything on Monday or Friday because those are my administrative days. And so that's a rhythm that works for me. So people know that if they've got a docket for me, they're going to see me on Tuesday or Thursday. If they have a pretrial or trial with me, it will start on Wednesday and then we'll go from there. And then that's kind of how everything is set up around there. It's really great because it does a couple of things. It gives me the flexibility for when all the emergencies pop up, and then I can plug in hearings and things as I need them. It allows me time to actually prepare for everything that I'm doing. So I have a career clerk and a term clerk, and I'm still one of those people who reads everything that gets filed that we're going to be talking about. So I read what you filed, I read what my clerks think about it, and then I form my own opinions, and then we go from there. It is nice because I am able to also plug in the other things I do. So in addition to being a judge, I am the president of a mom's organization. And we meet the first Monday of the month, and the executive board is the last Monday of the month. And then this past year, I also became the PTO president. I don't recommend any of this, but but because my days are flexible, because I'm the person who's in control of my schedule, I'm able to do those type of things. And I have to tell you, being able to do those things also kind of helped me, because you can get kind of bogged down in the sadness of consumer bankruptcy sometimes, because people are losing things, people are struggling through things, and just kind of having those things that kind of lift you up, help you continue to move forward. But your schedule is primarily your dockets, whether those be your motion dockets or your trial dockets, and how you set them up are up to you. So you have to figure out what rhythm works. I like morning hearings because then whatever happens in the day, I know that there is going to be a break at the end. Some of my colleagues split their dockets up. I talk really fast, so I don't need to split up my dockets as much as some people. And starting a docket in the middle of the afternoon is just really, that does not work for me because it feels like there's so many other things that have to happen in the afternoon. How are you going to get through this? So that's a day.
Okay, Janet, you want to tell us about a typical day in Boston?
Typical day in Boston. I'm still trying to figure out my rhythm, Jessica. And very similar. I try and avoid Monday and Friday because I know from how I operate that those aren't great days for hearings, unless I absolutely have to. I prefer morning hearings. Very similar.
And I think lawyers appreciate particularly not having something on Monday, because if you don't have a day to talk to all the other if you start something on Monday, they're not ready to talk about the case on the Friday before. They got to get to the day before, and it works better that way. But go on.
I must confess, next week, my hearing is on Wednesday for exactly that reason. I need Tuesday to get ready. And so there is a lot of prep time. I like Judge Price-Smith. I'm one who reads through everything, comes to my own opinion. There is a huge volume that goes through chambers. And a lot of it, some of it you delegate to your staff, your clerks. I have a term clerk and a career clerk. Some of it, but still there's some things that you need to see. So there's just a lot of administrative and volume of paperwork that never even gets to the hearing. And so we have what we call, case management. I try and block time for that. Block time. I'm still trying to figure out, some people do a week on, week off, so that they have time to write and do other activities. I haven't figured out that rhythm yet. The one thing I will say is you're scheduled far in advance. I have hearing dates for my consumer cases through December blocked off. And that, as a practitioner, it was like, yeah, you might have a conference scheduled in October, but you waited until the judge scheduled. But now you're the judge. You've got to lay things out a little longer. And so I think that's finding the right balance between time to prepare for the hearings, time to work on the decisions that you're not going to make at the hearing, whether it's an opinion or even just something you've got to prepare for so that you can go into the hearing, and trying to deal with just the routine work, trying to strike that right balance.
And Chris, you're the other experience with real hearing judge. So you want to give us any differences with Jessica and Janet? And then I'm going to ask Lori and Elizabeth what being a Zoom judge is like. So.
Yeah, the real hearings, I mean, in New Jersey anyway, even before pre-pandemic, we did a lot of, I allow telephonic hearings on just about everything. I mean, sometimes I'll ask the lawyers to come in if it's a difficult summary judgment hearing. Obviously, if I have to take evidence, the lawyers would come in. Many lawyers chose to appear in person anyway, because as we all know, there's so much that you read in body language. You can tell that you can't tell on Zoom, that you can't tell on a still photograph for a court solutions or a court call type of situation. So I miss that. I mean, going to Zoom was difficult in so many ways, which we all know. I miss the interaction with my staff. I mean, it's quiet enough anyway in chambers. I mean, you've got two people. It's me and I have a judicial assistant and a career clerk. and I miss seeing them. I think the interaction of even just the three of us helps with case management. Seeing each other in person helped a lot more with case management and production, just, writing and getting our thoughts all together. So I do miss that. I miss I want to go back to pre-pandemic, not totally, because there's a lot of good about sitting in my dining room here, but I miss the interaction.
Yeah, just for the audience that may not know this, each bankruptcy judge is entitled to 2 employees. Now, this is in addition to the people in the clerk's office, which support the judge. But those 2, I think that the trend, if you will, more now is for judges to have 2 law clerks. Some people like Chris have a judicial assistant and a law clerk. You can have 2 law clerks, but you're only entitled to 1 career law clerk, which is somebody that's going to work for you for more than 4 years, I think is the dividing line. But Elizabeth, Lori, one of you start with telling what your life as a judge is like in a Zoom world only.
So there's a lot of staff, including the clerk's office, I've yet to meet in person. Being sworn in from my living room, I didn't meet the chief judge. I have met the chief district judge in person. We happened to be in the building at the same time one day, but I've tried really hard to have virtual courtroom meetings every week on Zoom, just with my courtroom folks, to remind each other we exist, and that we're real humans and not just text messages or Teams messages and emails. But yeah, I was talking with the clerk the other day about they're going to open the courthouse at some point to allow people to come in and file, at least in the clerk's office. And I said, can you please give me a tour of what it looks like when the real world is happening in the courthouse? Because I don't know how that looks. And so for me, I also walked into a kind of a chief judge situation. So not only am I doing the docket prep and entering orders and all of that, I'm also dealing with budgets and things I didn't even know existed, because that's additional things. So I would like to say I spend half of my time working on the courtroom items and half of my time doing administrative items I didn't know existed before I came on the bench. And I still sometimes look sideways because I didn't know we had to do all it's in some of that's being the only judge, but some of it's also, I decided to write a new Chapter 13 plan and work on local rules, but I'm on judge committees and a number of other administrative things that also take up time. So to those of you who look and go, why the hell is it taking the judge 3 months to write this opinion? Understand that in those 3 months, we may have had 4 good solid days to sit down and really work on it. And the rest of it has been, as we like to say, other things jumping the queue. And so I never know. I come in with a plan every day, like Judge Smith, as to what I'm going to do that day. And by about 8:15, that's blown up because something has happened or an emergency was filed or whatever. I've also said just to my practitioners, please be patient. Learning to write from this side is different than writing your briefs and writing your motions. It's just a different writing. And while we have baby judge school, they don't give us writing like a judge 101. It's a lot more judicial temperament and how to manage our courtroom and things. And so I have spent the better part of the first 9 months on the bench relearning how to write as a judge in a judge voice as opposed to a lawyer voice. So I don't know if those are not some typical days, but there are a lot more behind the scenes moving parts that judges touch every day, interactions with the clerk's office and the administrative office that you never see, but it's what keeps the court functioning, setting those hearing dates, getting the courtroom and everything prepped for what actually you see as a practitioner on the other side.
Okay, we've got about 5 minutes left, and we've got one other topic I want to cover, obviously briefly. But that question is, what surprised you the most about being a judge? I know everybody thinks about what it's going to be like before they get there. But Lori, I didn't give you a chance on the last one. So what surprised you the most?
And I've been asked this question many times and I have to think about it, but I say the number one thing is the isolation. And that's not just a COVID thing. That is outside of COVID, but certainly COVID made it worse. But unlike Elizabeth, I do still go to the office every day, even though my hearings are on Zoom. I do them from the courtroom. I like that. And my staff is usually there. But going to the judgeship, but also moving cities, I don't have the relationships that I used to have. And so now I have to form new relationships, which is difficult in a virtual world. And so it's quiet in chambers. I don't get a lot of phone calls. I don't have lunches. Obviously with COVID, I haven't been out to lunch in so long. But your friends, you still have your friends, but you interact with them a little bit differently. And if they're attorneys that may appear in your court, you have to be careful about those things. And so it's a little isolating. I think that's probably the biggest surprise. The second biggest is also what Elizabeth touched on, which is the time constraints. I didn't realize how hard it was going to be to get an opinion out because you're spending so much time doing other things. And our district, the Middle District of Florida, is like usually within the top 5 of the busiest districts in the country. And so preparing for hearings, it's kind of this cycle that I go through every week. And so it can be hard sometimes just finding a few hours to sit down and work on your opinions.
Jessica, I know you've been nodding like.
So 2 things, the administrative thing. So if you're looking at a court that you think that you might want to get on, look how many judges that there are, because the fewer judges, the more administrative things that you have to do. So we have committees. And so, you are kind of the managing or the executive committee of the firm when you are the judge. And so the more people you have, the more it's spread out. But I will say one of the things that has been very surprising to me, and I learned how to handle these well from Judge Morgenstern Claren, who has retired, was you are the person who sees what's happening. You're the person who sees when the lawyers are getting in trouble, when their friends might not notice that their memory isn't what it was, or that something else is happening. And you need to figure out how you're going to deal with that. In the past few years, I have come up with situations with people with substance abuse, people with mental health issues. And unfortunately, one person who was in the beginnings of dementia and didn't realize it, because it is a sole practitioner. And so people were only seeing them in pieces and parts, but they kept coming in front of me. And I've had to be the person to say, something is going on here. You may need to talk to someone. And that was not something I expected to have to do.
Janet.
Well, I echo what has been said about the administrative. That was a surprise. I already said the scheduling in advance. Let me take it on a different tactic. One of the most pleasant surprises was when I was asked to do a naturalization ceremony. Mm-hmm. I did it in the middle of COVID. These are socially distanced outside. It was and for me, my grandmother came over through Ellis Island. So we had heard those stories. My grandmother and grandfather were naturalized citizens. And it was just such an uplifting experience. So the opportunities that are there to be a positive influence, that is one piece that has really been a pleasant surprise.
I think I'll add something on a different. Go ahead. I'm sorry, Christine. Go.
No, I would just add. I was pleasantly surprised at all the resources that are available to us as judges. Through the AO, through the Federal Judiciary Center, there's just a tremendous amount of support for the bankruptcy bench and the bankruptcy judges.
Yeah, and I was told we have an absolutely hard stop at 8 o'clock, and it's 7:59. So, well, I'm in the Central Time Zone at the moment, but I do want to thank all of the panelists. I think this has been great. One of the big surprises I think that I've learned is how wonderful all the other bankruptcy judges are, and how they come and bring such different experiences to the world that we live in. And they all are so dedicated to the profession. And this goes, as Christine said, to the people in the clerk's office, the people at the AO. It is an amazing court. And for those of you out there thinking about applying, if I took a poll right now, everyone would say this is the best job in the world. So
Absolutely.
thanks, everybody. And thanks to IWIRC for putting this together. I hope everybody got their CLE codes, and hopefully we'll see everybody in person, maybe in Indianapolis at the IWIRC meeting. Thank you.
Thanks,
Thank
everybody.
you, Mary Grace,
Bye.
for all your
Bye.
effort. Thank you.
Great.